Okay, well, I think we'll kick off this webinar now. I think we're a bit slow with the attendees joining, but I'm sure that everyone will join us. And if not, they'll certainly get a copy of this following the event. So I'd like to welcome everybody to the Russell Kennedy and Pride Living webinar. Serious Incident Response Scheme, are you prepared? Of course, I'm sure the answer to that is yes, but you'll be even more prepared when you have heard the content of today's webinar. What I'd like to firstly do is to acknowledge the traditional owners of the lands on which we are virtually meeting today. We pay our respects to the elders past, present and emerging. Now, of course, today's webinar is very topical. There's a lot going on in aged care. And indeed, tomorrow we're presenting on the Royal Commission final report. But even more pressing at the moment is, of course, our preparedness for the Serious Incident Response Scheme, which certainly kicks off a whole lot sooner than that. What I'd like to do is to just take you through a little bit of housekeeping first. So, Anita, if you could please move to the next slide. I'm sure that all of you will be able to take that in very quickly and take in the bits from it. Most importantly, what I'd like everybody to just focus on is the chat and the Q&A functions on the Zoom. On my screen, on the Mac, the chat and the Q&A buttons are at the bottom of the screen. The Q&A is exactly that. If you have any questions, then please ask those in the Q&A section, and we will be able to answer those. Generally, we've got panelists whom I'll introduce soon. We'll be able to answer those questions. Some may be referred to the speakers as well. Please note that we will not be able to provide legal advice or specific advice on any particular matter. So it needs to be more of a general question than a specific question dealing with a particular matter that's occurring. The chat function is just for that. Which is to make any comments, or if you've got some additional information that you think would be of relevance to us. And I can see that somebody's raised their hand, which you'll see in the chat function, and that's actually a very good use of the chat function there. Questions will be answered at the end of the webinar. We will send a webinar survey to you. We really appreciate your feedback. You'll have a QR code that links to the feedback survey, and we'll also be sending to you the slides from this presentation, and the webinar itself will be recorded, is being recorded for the purposes of transmission at a later stage. So you'll get access to that pretty soon. So what I'd like to do now is to actually introduce the presenters for today, and also the panelists who will be assisting with providing advice. And of course, we just skipped over the really important bit, which is the disclaimer, which I sort of went through anyway, about general commentary and not legal advice. But firstly, let me introduce to you Anita. Anita is a principal in our aged care team. Anita specialises in helping home care and residential care providers comply with their legal responsibilities. Her experience includes assisting providers in understanding their legislative and compliance responsibilities under the Act and the principles, and many other acts and the common law that apply to aged care providers. Anita regularly works with Pride Living and others to review providers' additional services offerings and to help them reduce their risks. And, well, the bio here tells me she's been assisting with federal court litigation. That's indeed correct, although that has now concluded. I'd also like to introduce Katrina Ong. Katrina is a partner, quality and clinical governance at Pride Living. As you can see, Katrina has substantial experience in clinical practice within the aged care as a registered nurse, and she has worked to transform the way in which resident care is delivered in aged care services. Katrina has a particular interest in supporting providers large and small to develop effective quality management systems, as well as to ensure their systems respond to the new aged care quality standards. And certainly that places Katrina at the forefront of being able to provide really useful and practical information to assist you so that you are prepared for the serious incident response scheme. Joining us also as panellists who will assist with answering some of the questions that you might be throwing our way include Kay Mann, who is a Principal, Clinical Governance and Quality Compliance at Pride Living. Kay is also a registered nurse with a highly developed clinical governance, leadership and operational experience. She has assisted providers in the areas of acquisitions and mergers, expansion, renovation, commissioning new aged care facilities, quality and compliance. She is also a specialist in policy analysis, writing, implementation and training. And she works with providers in the areas of quality improvement and operational management. So again, very well placed to be able to answer any of those tricky questions. And the final panelist that's joining us today is Joanna Heaven, who is a lawyer who works with Anita and I in the aged care team, and in that regard has had a lot of exposure to a wide range of matters involving aged care, as you can imagine, dealing with the regulatory compliance and litigation work that Anita and I do. So with that, I will now turn over to Anita to kick off from here. Anita will present an overview of the scheme, together with the definitions of serious incident for mandatory reporting, and look at the reporting and record keeping requirements. And Katrina will focus on providing tips on implementing the incident management system, the concepts of preventive and reactive risk management, and the concept of root cause analysis in incident investigation. I'm sure you'll get a lot out of this. Now it's your turn, Anita. The rest of us will turn our mics off. Thank you. And Anita, you'll turn your mic on.
Yes.
That's your cue.
Thanks to find it. Sorry, everyone. Thanks, everyone. As Victor said, we're so pleased to have so many of you here today, especially when there is so much happening in the industry. So I'm really grateful for you coming. So hopefully you all have a bit of an idea about what the SIRS or Serious Incident Response Scheme is about, but really it has two key elements. The first is it really fleshes out your obligations to have an incident management system in place and gives you a lot more detail about what that has to entail. And Katrina will talk a little bit more about that. I will run through some of the key, sort of basic elements there, but we will cover that in a bit more detail. Secondly, and I think more significantly, the scheme dramatically increases your mandatory reporting obligations. So rather than just requiring you to report allegations or incidents of assault and rough handling, sexual assault and also unexplained absences, you now have to report a much broader range of incidents and allegations. And as I'll discuss later, I think you will need to consider whether to make a report to the Commission every time you get a complaint about any type of poor care. So I will run through some of those later on. I think knowing what incidents and complaints to report is going to require a lot more analysis from you than was previously the case. It was quite easy to recognise an allegation of an assault or someone saying I've been handled roughly. Those sort of things kind of stick in your mind and they're quite easy to identify. It's a lot more borderline when we're talking about things like allegations of neglect or psychological or emotional abuse, as we'll sort of tease out. Okay, so the aims of the SIRS, I don't want to spend too much long time on here, but it's sort of about building provider capacity to better identify and mitigate risks of potential harm. It's also really about, I think, increasing the Commission's oversight of what's happening in the industry. And they say that's with the aim of helping to educate the sector on how to respond to systemic issues and things like that. But obviously there's also, the Commission's also given a lot more enforcement powers under this scheme, as we'll talk a bit more about. Okay, so there are two stages to the SIRS. You're probably aware of this. The first one, which is I think probably the major one, which commences in a couple of weeks, is that you firstly have to have your incident management system in place that complies with these new, more detailed requirements. And you have to report what are called priority 1 incidents to the Commission within 24 hours of when you become aware. The second, and I'll talk about what they are. Second stage is really increasing your reporting obligations to also cover what are called priority 2 incidents, and they have to be reported within 30 days. while I think in some ways stage 1 is going to be the most challenging, stage 2 is when I think your reporting obligations are going to really dramatically increase, because suddenly we're not going to be just looking at incidents that have resulted in harm, but things that are quite minor allegations. So I'll talk about that too. Okay. So as I said, Katrina's going to talk a bit about the incident management systems and how you can effectively implement that. But I thought I'd just run through briefly what some of the new requirements are. It dramatically increases. So currently you are required to have an incident management system in place, as you know, under Standard 8. But there's a lot more detail now in the quality of care principles as to what that has to entail. So, for example, it involves assessing and providing support and assistance to those affected. You have to involve each person affected by the incident or their representative in the management and resolution. You've got to use an open disclosure process. Of course, that's already something you should be doing. And then you have to assess whether it could have been prevented and what needs to be done. And also have to look at how well managed the incident was. So that's a sort of perhaps a new thing that we might not always do. But when you have done an investigation, you have to look at whether your response was actually appropriate. Your incident, you have to have a written or documented procedure that's available to not only your staff, but also residents and their representatives. And this has to document a range of things, which I won't sort of run through in detail, but that's the list there. So there are some things that generally we probably would have in there anyway, but there might be some new things in there for you. So I'd encourage you to have a look at that. Okay, it also now expands on what you need to include in your incident reports. Again, most of these are pretty obvious and you would already be doing it, but there might be some new things in there. So for example, you have to put in contact details of all the people involved, including witnesses. I have seen a number of incident reports and wouldn't say that they always have that information in there. You have to put in details of the consultation you've undertaken with consumers and the representatives involved, and also the details of the initial assessment and an investigation if you did one. So that's going to have to be in your incident reporting now. Of course, it doesn't need to be in your standard incident reports. You could have it in a separate document, but the point is you will have to have all of that as part of your incident management system. Another thing that's worth just noting is that you have to keep incident reports now for 7 years. For those of you in Victoria and New South Wales, you're probably already doing that because the health records laws in Victoria and New South Wales require that. But the Aged Care Act has always operated on a 3-year basis. So for those of you in other states, you will need to check that your policies do keep the documents related to incident management for 7 years, because that's maybe a new thing for you. All right, so now I'll move on to perhaps what is more the meatier part of this, and that is to do with reporting. So I thought it was worth just starting by really doing a bit of a comparison between the SIRS and the current or the old mandatory reporting obligations. So the first thing is, so what is different? The first thing is it's a much broader definition of what you need to report, and I'll talk through each of the 8 categories you now have to report. So another thing that's different is that you no longer need to report every single incident that you report to the Commission to the police. You only have to do that if you suspect or it is alleged to you that the incident involves a criminal offence, or there are other reasonable grounds to report the incident to a police, or if it involves an absconding resident. So all of those things have to be reported to the police, but otherwise you don't have to report all of the allegations. There's also another major difference is that there's no longer any exception where the harm or the incident is perpetrated by someone with a cognitive impairment. And I know you're probably all well aware of that by now, but that is a major shift, and we'll see, I think, a dramatic increase in the number of allegations that are reported. Another thing that maybe not that important, but is a kind of interesting distinction is that previously where an allegation of assault was suspected to have occurred, you were only required to report it if you suspected it on reasonable grounds. Those words, reasonable grounds, have now gone, so it's just any suspicion. So one might query if someone in your organisation has a very vague suspicion that something has happened, then are you required to report it? Possibly. And then the other thing that's changed is that you have to confirm when you're making the report that you've provided a notice of collection to any person you're talking about in the report. So that would not only be the resident, but any family that may have been named in there and the staff. That's a new requirement, and one that I think could be a little bit tricky to sort of manage, because typically if you're making the report within 24 hours, to have also said we've also sent a notice of collection to the son who the report is about, you know, it does add a bit more of a burden for you there. Okay, so what hasn't changed, I think it's also worth being aware of. The time frame for reporting to the Commission is still 24 hours. When you become aware, you still need to report any allegation of a reportable incident, regardless if it's unreasonable, regardless if it's totally delusional, and you know that and you have evidence. And you still need to report all your assault type allegations to the police. The scheme still only applies to residential care, although of course the Royal Commission has recommended that these sort of obligations also apply in home care, but currently we're only talking about residential care. And another thing that hasn't changed is there's no discretion to report if the consumer doesn't want you to. And just on that, I have found it interesting, the talk about the politics in Canberra and the processes around reporting allegations of sexual assault. And there's been a lot of talk that, no, it shouldn't be a mandatory report. It should be the victim's choice. And yet when we're talking about aged care, then people will lose that right to say no. And I think that's a really telling sort of, it tells us how we really do still treat people, elder people, with sort of in a quite paternalistic way. And then finally, other than stealing or coercion, it doesn't matter who perpetrated the incident against the consumer. You know, it could be a family member, it could be a staff member, you still have to report it. And that's something that wasn't necessarily always going to be the case with the recommendations on this scheme. And I think it is actually quite helpful, because where it is a family member, residents may not want you to report. Okay, so talking about priority 1 and priority 2 incidents, remembering that the difference here is that priority 1 incidents are reportable from the 1st of April. You'll have till the 1st of October for priority 2. And also there's different timeframes. So priority 1 incidents are ones that result in harm or could have caused harm, and that really requiring medical treatment. So it's sort of quite a high threshold. They also include any unexpected death or unexplained absence, and also where you've suspected a crime. So those are sort of the 3 limbs of what is a priority 1 incident. And then priority 2 are basically all other incidents that fall in the definition of a reportable incident, but don't cause harm. I will just note here that the Commission's guidance says that priority 2 incidents are incidents that result in a low level of harm. However, the legislation doesn't say that. It just says that priority 2 incident is anything that's not a priority 1 incident. So if it falls within the definition, doesn't matter if the consumer has suffered any harm whatsoever, you still have to report it, in my opinion. And the Commission basically says, if you're not sure if something is priority 1 or priority 2, be guided by the consumer. If they're saying that it's affected them, or you know they're distressed by it, treat it as priority 1. Okay, so now we'll go into the details of what are actually reportable. So there are 8 categories, and these aren't the order they appear in the legislation, but this is an order that sort of made some sense. The first 3 are ones that will be familiar to you, because they're either very similar to, or well, they really are very similar to what's already reportable. So the unreasonable use of force, unlawful sexual contact, or, and this is new, inappropriate sexual conduct, and unexplained absences from care. And then there's another 5 categories that are new. So psychological or emotional abuse, unexpected death, stealing or financial coercion, neglect, inappropriate physical or chemical restraint. So I will talk about each of these in more detail now. So unreasonable use of force is defined as a conduct ranging from a deliberate and violent physical attack to use of unwarranted physical force. So it's really quite similar to what you are already required to report it. And the Commission gives these examples: shoving, hitting, throwing things, making threats of physical harm. I did think that one was interesting, because I wouldn't necessarily have automatically thought that a mere threat would actually constitute unreasonable use of force. So query that one. Spitting at a consumer again, one that wouldn't sort of necessarily automatically stick out as an unreasonable use of force, although it would actually constitute an assault at law. And then a pattern of rough handling. Personally, I think an allegation of rough handling or any incident of rough handling probably constitutes unreasonable use of force, regardless of whether there's a pattern or not. So that's just worth thinking about. And what the Commission says, it doesn't matter if someone didn't suffer any harm. If it falls within these categories or this category, then it's reportable. So what unreasonable force does not include is sort of things, sort of the stuff you would expect. So gently touching someone to guide them or to provide them with care or to attract their attention, accidental contact, physical contact where there's some lawful justification for it, and also reasonable management. So if a consumer happens to get a bump while care staff are providing care perfectly appropriately, that would not be unreasonable use of force. So those are some examples. And there is more examples of everything in the Commission's guidance, so do have a look at that. Okay, unexplained absences from care. This is probably a category that's fairly familiar with. The thing I would just note here is that they are all considered priority 1 incidents, and you need to report to the police, I think, first before you report to the Commission. You have 24 hours for the Commission, but you shouldn't be waiting that long to report to the police. You should do it immediately, because the sooner you get the resident back, the less risk you're at. So I would just encourage you to just make sure you're reporting those things as quickly as possible. And if they do turn up in the 24 hours, the Commission says is if you have reported it to the police, then tell us as well. But if you hadn't gotten around to reporting it to the police because they kind of appeared as you realised they were missing, then you don't need to report it. Okay, now getting into really what are, oh, hang on, I might have, we need to go back to unlawful sexual contact, my apologies. So this one, again, some of it's going to be quite familiar to you, and it's really in any sort of sexual assault. But they've made it much clearer now that any sexual contact with the staff is an assault, regardless of whether it's consensual or not. So that's just worth noting. But interestingly, they've excluded volunteers, provided the sexual contact doesn't occur while the volunteer is on a shift. And the rationale there is that if someone's wife or husband happens to volunteer at the facility, we wouldn't want to make them having sexual contact in their own time an offence. So provided it's consensual, then sexual contact with a volunteer would not constitute a reportable incident. However, anytime a staff member has sexual contact, that will constitute a reportable assault. The inappropriate sexual conduct category is sort of new and quite a bit broader. So that's things like sharing intimate images of the resident or any sort of grooming type behaviour. So that's that conduct relating to the resident with the intention to make it easier to procure the resident to engage in sexual contact. So it's a much broader category in that respect. One thing that I don't think has been clearly answered by the Commission is if you've got two residents, neither of whom can consent, but also neither of whom have the capacity to form a criminal intent, would you have to report that? I would probably err on the side of just reporting it, particularly if you've got family saying my mother was assaulted, then you would probably just report it, but query whether it actually is required, because if someone can't form a criminal intent, they also can't commit that crime. And so you can understand how that might be difficult to work it out. Okay, so I've talked about unexplained absences from care already. Okay, so now I'll just move on to what are the really new categories, and I think probably the more tricky ones. So psychological or emotional abuse is defined as conduct that has caused or could reasonably have caused consumer psychological or emotional distress. And then it gives a whole lot of examples in the legislation of what that is. So threats of maltreatment, taunting, bullying, harassment, intimidation, humiliation, and even sort of teasing or type conduct where it's repetitive, say deliberately calling someone the wrong name. And the other one is, I think, what I would just call the silent treatment. So it's quite a broad category, as you can see there, and could be hard to spot, particularly when you're talking as between residents. Residents might not particularly get on well, and they mightn't talk to each other, and that would then be reportable. This is some examples that the Commission gives on this one. So staff members yelling, I mean, that's quite obvious. A staff member giving abrupt, terse or brusque orders to a consumer. A family member making inappropriate or cruel comments or jokes to or within earshot of a consumer. And things like flicking, taps and bumps to a consumer, and threatening or aggressive gestures. So it is a really broad category, as you can see there. The other very broad and new category is neglect. And I think this is the one that's probably the trickiest and potentially the most onerous in terms of your reporting. It's defined in quite a legalistic way. So firstly, it's a breach of duty of care or a gross breach of professional standards in providing care or services. So, you know, if a nurse has clearly not met her or his obligations under the nursing board's codes of conduct. These are some examples the Commission gives: failing to properly supervise a resident, failing to dress a resident appropriately for the weather, withholding personal care, toileting or oral care, and failing to treat injuries, wounds, pain, etc. Failing to call an ambulance when required. So those are some of the examples. Again, go and have a look at those examples given by the Commission in their guidance. Unexpected death. This is also new. So this is where reasonable steps were not taken by the provider to prevent the death, or it is the result of care and services provided to the care recipient, or it is a result of a failure of the approved provider to provide care or services. So there's a little bit of overlap with the neglect there, and it's possible that you could have an incident that's neglect that leads to an unexpected death, so it's reportable on both grounds. And what is not an unexpected death, and that's one that's, well, expected really, as they say here. So death resulting from, you know, an ongoing illness or condition. So this is some examples given by the Commission. So a death that results from clinical mistakes or an untreated wound becomes infected, there's medication error, the consumer has a fall and they're not sent to hospital immediately, and then they die later from their injuries. It doesn't matter when the death occurs in terms of the incident. If the incident was sort of caused the death, it will be considered a reportable death. So, you know, this comes up in coroners all the time, where there may have been a fall a month prior to the death, and that will then lead to the resident getting pneumonia and dying. So that would fall within the category of an unexpected death, potentially, if the fall was in some way the fault of the approved provider. If you are unsure, I think you're probably better to err on the side of caution, particularly where it's unclear what caused the death, and that's what the Commission says you should do. And just remember, all deaths are considered, all unexpected deaths are considered priority 1 incidents. So it's not that you have to report within 24 hours of the death occurring. You have to report within 24 hours of you becoming aware that the death was unexpected. So just being aware of that distinction, because it may take you some time to work that out. Okay, next one is inappropriate use of restraint. And really, that's any use of restraints outside the quality of care principles. It's a fairly simple definition. And where I think it's going to be most problematic for providers is when it comes to keypads and secure units. If you do not have the appropriate consent and authority from a health practitioner to say that the consumer should be in that secure unit, or that they shouldn't be allowed to leave the facility whenever they want, then you are potentially restraining them, and that will be reportable. So if you don't have good documentation around that at the moment, you do need to get that in place. Remember, if a consumer does not want to leave the facility, then that's not restraint. But if they want to leave and you're not letting them just because their family say, I don't want mum being able to walk out, then you do need to get your restraints authorisations in place. So do have a look at that if you need to. And we certainly have some forms and templates available if anyone needs assistance with that. Okay, next category, and we're nearly there, is stealing or financial coercion by a staff member. So this is theft and also Conduct by a staff member that is coercive or deceptive in relation to financial affairs or unreasonably controls the financial affairs of the consumer. Remember, it's not every time an item goes missing, it's where you suspect that it is a staff member. However, the Commission actually says if a consumer is unhappy that something's gone missing, you have to report that, even if you've got no basis to think it was a staff member. So I'm not sure the Commission's right there, but it gives you a bit of an idea of their thinking. Again, it's very much about what does putting the consumer at the centre of things. These are some examples. It's really accepting or soliciting gifts or getting someone to change their will. The Commission says if someone's using their power of attorney inappropriately. But I would say, why on earth would your staff be powers of attorney anyway? So that shouldn't happen in the first place. And then the Commission says they're things that are not reportable. So the consumer buys the staff member a coffee without them asking for it, for example. That's not going to be reportable. Okay, so that's all the categories of what's reportable. And there are a couple of exceptions to when something is reportable. I'll just quickly run through. And that is if the incident has not occurred in connection with the provision of residential care. So in other words, if it occurs outside the facility, there are no staff around, it may not actually be reportable. So, for example, if the resident is in hospital, that's not going to be something that's reportable. However, that category is considered to be very broad. So if there's a staff member attending, or if the consumer is going out of the facility to get specialist treatment, then it may still be reportable. Okay. The other category where it's not reportable is where there's been a dignity of risk decision by the consumer. It's not the word that's used in legislation, but I think it sort of makes sense. So these are things like where the consumer declines to follow advice that you've given, or if, the dysphagia one is a common example. But I think in that category, if you are looking at relying on that to say something has happened and it wasn't our fault, I think you're going to need to just make sure you had really good documentation in place to demonstrate that it was a dignity of risk decision. And I think there's also always going to be a question. So for example, a consumer refuses to go into the secure unit and then they abscond. I would still be reporting that. For one thing, you have to report it to the police. It doesn't make sense to report to the police and then not the Commission. So you would be wanting to do that, even if you say, well, we tried to have them in the secure unit. And also the Commission might say, well, despite the fact that they weren't in the secure unit, it was your fault for not supervising them. Just before I sort of wrap up, remember that unmeritorious complaints are reportable, and that's because any allegation of any of the above is reportable. And I think when we think about that, it suddenly dawned on me how broad your reporting obligations are now. So for example, a resident complains they waited too long for a shower this morning. That may be an allegation of neglect, even though you may say, well, they got showered exactly the same time that they normally do. Or the daughter visits and she says, Mum wasn't dressed appropriately for the weather. And we say, well, actually, Mum chose her own clothes and she said she's very comfortable. That's still an allegation of neglect. So that would need to be reported, in my opinion. Resident who's on a controlled diet, they say they're not being given enough to eat. Again, even if they're being given the appropriate amount and they actually don't have capacity to make a decision different to that, and if their family haven't let them as the guardian, then that still could be reportable. A resident alleges that overnight staff keep stealing her lollies. You know that the resident actually eats all her lollies herself, but that's an allegation of theft. And resident complains that another resident who has dementia ignores them. That resident is alleging psychological abuse. So that again is reportable, even though you know the other resident just doesn't communicate. That really, I think, gives you a sense of just how broad your reporting obligations are now. And it's why I said at the outset that anytime you get a complaint, you may actually have to make a report. So there are a range of consequences for not complying with the SIRS. I'm not going to go into them. It's the usual stuff, but there are some additional penalties, particularly where you, for example, victimise someone who has made an allegation. So just to wrap it all up and hand over to Katrina, your incident management reporting obligations are much more specific and detailed now. So make sure you're meeting all of those requirements in the legislation. You need to report all reportable incidents that have occurred or are alleged or suspected to have occurred, and that will include some frivolous complaints. There are timeframes that differ depending if it's priority 1 or 2. There's no longer any exceptions if something is perpetrated by someone with a cognitive impairment. You only need to report to police, though, if you suspect a crime or the resident is missing. And make sure your record-keeping processes are compliant with the 7-year requirement, noting that that has changed. And finally, the SIRS operates alongside other mandatory reporting obligations, such as NDIS and APRA. So make sure you do both reports if needed. So I will hand over to Katrina.
Good morning, everyone, and welcome. So pleased that you could join us today. Thank you, Victor, and thank you, Anita, for that really good overview. So much value and so much good examples from that presentation and report. My session won't necessarily go through what the Commission has already discussed with their sessions. So if you haven't watched them already, I do suggest that you watch them. Those SRIS webinars, there is really good value in them. But my session will really focus on some of the practical and hands-on tips that you can consider and implement when thinking about strengthening your incident management systems, as well as delve into the process of investigation. Next slide, please, Anita. So it is an expectation that for every approved provider, there is an incident management system that already exists. So the goal really for all of the approved providers is to improve, strengthen, and align the processes with the definition and the changes. So firstly, look into your organizational frameworks that underpin the organization's performance. In our view and experience, all of these three are aligned and go hand in hand. So ask yourself, do you have a robust clinical governance framework? One that drives and defines the clinical effectiveness in the care and services that you provide. Do you have an effective risk management framework? A risk management framework might sometimes be classified for broader organizations for enterprise risk, but clinical risk is really crucial as providers are in the core business of providing care. Note that the risk management in the SRIS context may also be broader than just the focus of clinical risk or harm and high impact, high prevalence risks. Some organizations may have 3 levels of risk management, may be defined differently, but in the context of ISO principles, you can consider first tier, which is people who are hands-on, second tier, which is your validation partner or providing a fresh set of eyes, or third tier, which is your certification bodies such as your ACQSC or WorkSafe. And lastly, do you have a quality management framework? So this is equally as important as the other 2 frameworks, because this is the actual framework that makes the other 2 frameworks sustainable and efficient. So focus on the 4 pillars of quality management, such as quality planning, quality control, quality assurance, and quality improvement. So some of the more practical tips are, so this goes without saying that consultation and engagement is the most important and crucial step. So consumer engagement, such as the residents and their families, inform them of the changes in the legislation and the obligations in the provider in reporting. So they must be made aware so that they're not surprised should an incident occur and should you be involving them in the consultation process. Staff consultation, so find out what it is that your staff already know and work from there. Most importantly, as managers, I think one question you need to ask your staff is to actually identify, can they actually identify and spot that something is wrong, and should they do something about it and report it? Don't forget your contractors, so informing and consulting your allied health staff, your cleaners, laundry personnel, and your GPs are important as well. So Anita spoke about policies and procedures. Think about position descriptions and audit tools. Make sure that they're easily accessible, easily understandable. We suggest using flip charts for easy access, particularly to visitors and contractors. And it's also important to include accountability as well. Thinking about education and training, think about do competency testing. So do they understand the concepts of SRIS and incident management? I think one good thing when you're doing education and training is to use case studies. So de-identify real life scenarios, use transparency and open disclosure, and it may have a direct impact to your staff when you're doing education and training in their learning if the scenarios are real to them. Think about compliance mapping. So incorporate with your staff journey and experience and their understanding. So where some organizations have mapped the consumer journey, it's also beneficial that it goes hand in hand with mapping your staff journey as well. How do they understand their process? How do they understand the organization's process? And in this, you also have to think, do your policies, procedures, position descriptions, audit tools, clinical management softwares, and incident managed softwares align and are seamless and are easy to understand? Some of the practical challenges that providers may face would likely be when using commercial softwares. So do these systems align and have the same definitions? Because organizations may have a different clinical management software, a different staff and hazard reporting, different incident managed reporting. So it's really easy to miss one step and get confused. So nextly, think about your reporting framework. Does your organization have a no blame culture? So as we mentioned earlier, do your staff know if they need to report it, who to report it to, or is there any fear of repercussion in reporting? So is the culture embedded in the organization that residents are receiving safe and effective care and services? And then lastly, think about your communication pathway. So your internal escalation, do they know who to report if they cannot report to management? And is there a whistleblower policy? And an external escalation, which is the really tricky one because the Commission hasn't provided any guidance yet on the My Aged Care portal access. So that might be something that you really need to consider and also have that front in mind because we all know that there are particular challenges in implementing the national quality indicators. So ensure that your staff have access and also being able to report in a timely manner. And you would hate to think that access would be the barriers for them to report within the 24 hours. So the goal is really to avoid the delay should you have to report. Next slide, please, Anita. So I want to talk about the journey of risk mitigation. So traditionally, risk management occurs through hindsight, where the incident has already occurred. Unfortunately, the tone of the SRIS seems really scary for providers. Honestly, watching the Commission's webinar, I can't count how many times the words "the provider must" was used in the webinar. It really goes to show that there is an extreme heavy focus on compliance, regulation, and obligation to report. But at the end of the day, the most important thing that we really need to consider is how are we keeping our residents safe and preventing these incidents from occurring? Organizations must move to actively identify the risk and move from being reactive to proactive. So by analyzing the trends, you will be able to manage, mitigate the risk, and most importantly, sustain the improvements and prevent the incidents from occurring. In the next slide, I'll be discussing proactive and reactive risk management activities. Next slide, please. So realistically, some incidents fall beyond our control. It's really important to understand the concepts and the difference between proactive activities and reactive activities. Proactive activities are repeatable activities which occur on a schedule. They address potential problems as well as existing ones. So they may be in the form of audit schedules, clinical or risk indicator trends analysis, and etc. There is a systemic approach in involving quality control activities. So quality control activities is defined as the strategy of detection and finding holes in the system. So I'll explain these more in the next few slides when I discuss the Swiss cheese model. Then reactive activities occur when they are triggered by a specific event, so more analytical, and may result in a deep dive such as a root cause analysis. Risk management and continuous improvement go hand in hand. because one of the tricky bits is some providers only focus on risk management without the actual quality improvement. So the improvements may not be sustained. So you're identifying the problem, but not really doing anything about it. So the goal and aim is to break the cycle of reporting due to the implementation of sustained improvements identified from proactive and reactive risk management activities, particularly with the RCA, where the goal is to identify the root cause and the aim is to eliminate the problem. Next slide, please, Anita. All of us know what a Swiss cheese is. I think this is a really good analogy in describing proactive risk management. The holes represent the unaddressed systemic issues. So it's really important to actively find holes in the system. So in the case with the SRIS examples, the holes might be the following. So systems and processes are in place, but are ineffective. So we see this in larger organizations where there are really good systems and processes in place, but in a facility level, they're not as effective, which results into a direct impact on the consumers. So there might not be testing arrangements. So meaning the systems and processes are not tested for its effectiveness. For example, testing outbreak management plans. There is a lack of reporting or governance oversight. And there is a lack of staff awareness or confidence in the systems and processes. Next slide, please. So what happens when the organization doesn't proactively identify the holes and implement systems and processes in place to mitigate the risk? It's too late to mitigate the catastrophe. It's too late to mitigate it because too late to mitigate the catastrophe, as the speed on going through the holes might be too fast to mitigate. So I relate this to chronic wound management, where prevention is better than cure. If the resident is churned regularly, there may be a decreased need for the RN's time to address chronic pressure injuries, decrease overall wound management rounds, and the need to purchase wound dressings. So think about it the way where prevention is better than cure. Next slide, please. So let's talk about reactive risk management. So an RC, root cause analysis in incident investigation. So it's really important to, in an RCA, to identify the true cause of the problem and its effects. It's a structured and realistic approach to problem identification that can provide your organization with a solution-driven opportunity for positive change and enhance the effectiveness of the corrective action systems. So the RCAs might be conducted by either an independent person, and there is a lot of value in getting an external view, so where there is a fresh set of eyes removed from the situation, and it can be conducted in workshops as well, where there are different teams working through together to formulate the problem and create the solutions. So the most important step for an RCA is to correctly identify the problem. So the system can only improve if the problem is known. So the root cause of the problem must be understood clearly before the corrective actions and preventative actions can be implemented. So truly identify the cause of the problem and not just address its symptoms, because sometimes only the obvious is addressed, and it's really important to identify the factors that contribute to the problem. So ask the 3 W's and H. So why did it happen? Who was responsible? And how can we prevent this from occurring? So the goal really is to reduce crisis management and avoid band-aid solutions and prevent the incident from occurring again in order to reduce resident harm. And that concludes my side of the presentation. We're really interested to know how everyone's feeling right now. Are you prepared with the new changes? We'd like to hear from you in the chat session about your level of preparedness.
Okay, well, thank you for that really interesting conversation. I think we are, hopefully we'll get some feedback, Katrina, in terms of the that state of preparedness. I think that we have also seen, well, I know we've also seen a number of questions that have been asked and answered by our panellists, and everyone can have access to those. You can see in the answered section some of the information that has been provided. We have one more question, which Anita's typing the answer to, but perhaps, Anita, you might want to answer that live, where the question's been asked about being confused about treatment by nurse, doctor, allied health professional, staff provide treatment for burns or cut skin, do we report the incident? What's your view on that? You might have to unmute yourself, Katrina. Sorry, Anita.
Sorry, I'm going to understand this question to be if a doctor or allied health professional caused the injury. I'm hoping that that's right. Because that has occurred, I think, in connection with residential care, then yes, that would be reportable. If it occurred outside the facility, say in hospital when your staff weren't there, then no, it wouldn't. But if it occurs in connection with the provision of residential care, then yes. But if I've misunderstood the question, please shoot through another one and we'll address that.
Thanks, Anita. I can see Rick has asked a question in relation to an estimate of time involved for staff to manage the documentary requirements and to involved in staff in notifying staff to complete the necessaries following notifiable incidents. I can only imagine that it takes a significant amount of time to deal with the paperwork, let alone actually attending to the incident. Katrina, do you have any, or Kay indeed, do you have any experience or insight into how long you think it would take for staff to answer these questions? Well, not answer the questions, I'm sure it won't take long, but actually complete the paperwork.
I think that this is, I find that while the reporting is broader, it's no different to what we currently do. I think the tricky part is the My Aged Care access, because that one is the barrier that I find in with regards to the change. Because currently what the providers are obligated to do is to fill out the form and email that back. So we have yet to actually find out what the My Aged Care portal looks like. So that is a watch this space, unfortunately, that we can't answer at this point in time. But I don't envisage that what we would normally do before and now would be different. It's just we don't know what the My Aged Care portal looks like in terms of the reporting. Is a challenge.
Thanks for that, Katrina. Hopefully, Rick, that provides a little bit of information, but I'm sure that many of you will have some practical experience, be able to share that at some stage, because it is going to be a ramp up on what we're experiencing right now. And as somebody has pointed out, Marie, in the chat section, I'm sure we're all feeling very nervous about the huge workload that's associated with this, with what comes with this. Obviously, the policy intent is that it's of the most serious matters, and we're responding to the public policy in terms of what's needed. But yes, it will be a huge workload and just another burden to deal with something that's serious. Now, Deb has asked, what if a stage 4 wound had not been identified? Now, I think that's quite a specific question, but I don't know whether Katrina or Anita, you would like to answer that as we are closing in on the conclusion of this webinar.
I would say that probably falls in that category of neglect. So yes, it probably would constitute a reportable incident.
Okay. All right, well, I think what I might do is ask, I think that what we might do is bring this to a conclusion. I wonder, Anita, Katrina, do you have any final comments to make before we wrap up this session?
Just good luck. It is a big increase in the burdens, but I think that the Commission will have a little bit of an understanding approach as providers roll this out. And they've certainly the comments they've made are that if they can see you're trying to do the right thing, they're not going to come after you. It's where you're deliberately not trying to do the right thing that they'll start to use those more onerous enforcement powers. So, but certainly I think that there'll be learnings for all of us over the next 6 months.
Thanks, Anita. Katrina?
I think that it is going to be a challenge, particularly with regards to implementing and understanding staff knowledge and also consumer knowledge as well. So if there's anything that we can assist anyone, just feel free to reach out, because I think the Commission is also trying to find their feet as well in this. So again, the same with the what we went through with the transition to the new quality standards. They're learning as we're learning, which is the same challenge that we're finding now.
Okay, great. Thank you for that. And I've noticed that the questions now have come in thick and fast, which is great. Please be assured that we're going to do our best to continue answering those questions. So I'm sure Kay and Joanna are typing away furiously, and I can see Katrina and Anita are also typing away. So hopefully by the time I finish my little spiel, the remaining questions will have been concluded. But what I'd like to do is to, in particular, thank Anita and Katrina for what's been a very enlightening webinar on what is undoubtedly a complicated step-up scheme in terms of serious incidents. I'd like to thank everybody for attending today. We've had an enormous attendance and some really great questions that have been asked, which we've attempted to do our best to respond to. And there will certainly be follow-up from us in relation to this as we get more and more on top of it. What I'd like you to do, of course, Pride Living and Russell Kennedy are happy to provide specific advice to you if you'd like to contact us, and obviously the contact details are there. You can scan the QR code to provide instant feedback on the session. We'd love to get your feedback on it, including any further topics that might be there. We're obviously here to assist you through this, and we look forward to hearing from you, and wish you good luck on your journey in terms of coming to grips with it in amongst everything else that's occurring as well. So once again, thank you. I can see that we have got those questions down, but I think for the moment we might just say goodbye and have a great rest of the day. Thank you.
Everyone.